darker than the night that hides them. Wicked as the worst of felons could devise. Robust social debate encouraged by the first line of defense. Sixth and First Amendment to produce express when face-to-face in civil disobedience by court officials. Decency, security and liberty alike demands that government officials shall be subject to the rules of conduct. United States courts and government is the potent omnipresent teacher for good or bad. It teaches the whole people by its example. Official crime is contagious. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man and woman to become a law unto themselves. States, and the capital of the United States must address it robustly and effectively. But civil society also has an important role to play, particularly in raising awareness of the threat, addressing underlying conditions that breed court abuse. When officials fail to enforce the laws, citizens must step in and take action. Judicial and public notice for the record is corrected, the lie exposed and the system indicted. Respectfully submitted in the public domain. Michael Ryan Durr, living man. Survivor, advocate of his own rights. Location: Delaware County Courthouse, Media, Pennsylvania. This is an introduction of a living declaration for the dead by Michael Ryan Durr. Local government provided retaliation and harm to my man for immediate media and public record notice. The weaponization of the court should concern us all. Unjust detention, a silent pandemic that is afflicting the towns in PA. I was referring to the phenomenon called lawfare, derived as a portmanteau of the words law and warfare, which is used to signify a form of war consisting of the use of the legal system against a perceived enemy, such as by damaging or delegitimizing them, tying up their time, or winning a public relations victory. Universal notification, informing all relevant parties, members of communities and society about a specific event, action and deceptions. It ensures that everyone who may be affected by something has the opportunity to be aware. This can apply in various situations, such as providing notice to parents and staff about pesticide applications in social order, schools, potential disasters, and local court abuse. Delaware County Courthouse judges, district attorneys with clear intent engaged in tempering and modifying court statute with false solutions to a statute, allowing fabricated statements, fabricated evidence, incriminating innocent community members in cloaked judicial authority with those hearings for illegal personal gain in enforcing plea deals and false convictions in court process. Engaged in embezzlement in public funds. Clearly neglecting. Breach of public trust in their legal performance under contract, bonds, and oath of his or her profession under the title. Judges and district attorneys, in fact, to interfere is to commit professional suicide in committing treason and perjury in violations to Title 18 U.S. Code Section 2381 treason and Title 18 U.S. Code Section 1621 perjury under oath, following countless civil and criminal trespass and criminal charges that destroys the very fabric of his or her own occupation, and abrogates the First Amendment, the Pennsylvania Constitution, Article 1, Section 1, Section 7, Section 17, Section 26, which establish the people as a whole. Judges and district attorney refuse to perform their own sworn oath but continues to cash their paychecks, constitutes fraud, and only performs judicial and district attorneys' atrocities of law in dereliction of duty, defalcation in disregarding all laws, and direct violations to Title 42 U.S. Code Section 1986, neglect to prevent Title 18 U.S. Code Section 241 and 200 42 Title 18 U.S. Code Section 371. Judicial racial classification is treating people differently through a process of judicial discretion into categories not necessarily related to race, and that there is widespread intentional legal abuse in the workplace and the courts. In addition, judges and district attorneys conspiring in defrauding state statutes for their personal gain. Legislative statutes intended for its purpose are all void. Board members are fully equipped on code of professional responsibilities and engaged in turning a blind eye with clear intent within the components of the mens rea. Here bar members are in direct violation to DR 7-103A, DR 1-103A, DR 1-102A 1-6. Courthouse, Media, Pennsylvania prosecutors has been in direct violations to DR 7-103A and B for years, and no one is talking about it. A prosecutor in a criminal litigation shall make timely disclosure to counsel for the defendant or to the defendant if he has no counsel of the existence of evidence under its docket known to the prosecutor or other lawyers. Delaware County Courthouse, Media, Pennsylvania prosecutors has been again violating clear intent for years. Pennsylvania Constitution's Article 1 Section 9 right of the accused unimpeded criminal defense. Granted with the Sixth Amendment United States Constitution. Denial of a fair trial and malicious prosecution has been consistent here. What did they teach in law school? Brady Rule and Disciplinary Rules DR 3-101 aiding unauthorized practice of law. In Brady decision ruled that the defense has the right to examine all evidence that may be of an exculpatory nature. The prosecution will not only release evidence that the defendant might be guilty of a crime, but also release all evidence that might show that the defendant is innocent. Pennsylvania Rules of Professional Conduct Rule 3.8 not seek to obtain from an unrepresented accused a waiver of important pretrial rights. Full defense. Full disclosure of evidence. Any and all tangle items. Pennsylvania Rules of Professional Conduct Rule 3.8d make timely disclosure to defense of all evidence known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. The Supreme Court has eliminated the requirement for a defendant to have requested favorable information. Prosecutors' duty to disclose material and exculpatory evidence is not triggered by a defendant's request, but simply by the evidence's existence under statute. But here statutes are being misused in the highest fraudulent manner as to commit treason and perjury without any consequences with clear intent. If the judge doesn't fully comply with his bonding oath, then the orders by that bench are void. Void I-124 Utes 200. He or she is without jurisdiction and he or she has engaged in an act of treason. Welcome. Black's Law Dictionary 8th edition. Manifest necessity. See necessity. Black's Law Dictionary 8th edition. Under necessity, manifest necessity, a sudden and overwhelming emergency, beyond the court's and parties' control, that makes conducting a trial or reaching a fair result impossible and that therefore authorizes the granting of a mistrial. Black's Law Dictionary 8th edition. Mistrial. 1. A trial that the judge brings to an end, without a determination on the merits, because of a procedural error or serious misconduct occurring during the proceedings. Defendant contest in regard to Rules of Professional Conduct Rule 3.8 and selective enforcement and selective prosecution. A denial of a fair trial falls right in the Pennsylvania Rules of Criminal Procedure Rule 605b. When an event prejudicial to the defendant occurs during trial, only the defendant may move for a mistrial. The motion shall be made when the event is disclosed. Otherwise, the trial judge may declare a mistrial only for reasons of manifest necessity. Manifest necessity be found in Commonwealth v. Stewart 317A.2d 616. See Part 2 video.